Good afternoon, Professor Ho, Pooja, Professor Johannes Chan, Professor Albert Chen. First of all, I thank Professor Lucina Ho for inviting me to speak today, and I thank Pooja for making the arrangements for my talk. Receiving Professor Ho's invitation made me lament the passing of time. My first encounter with Professor Ho took place some 27 years ago, when she was a first-year undergraduate and when I was a postgraduate student in England. In a juvenile and playful way, during that first encounter, I scared the living daylights out of her by jumping up outside her window in an ancient Oxford college at night. Sorry, Professor Ho, for revealing that you are at least 27 years old. Speeches at opening ceremonies tend to be very boring. When back in March this year, Professor Ho asked me to speak at the opening ceremony, I thought, oh my God, I had to say something boring, such as work hard, play hard, 上莊, be good boys and good girls, don't let your parents down, etc., etc. However, given incidents recently in Hong Kong and in Hong Kong U, I have decided that I would be failing in my civic duty if I were to say anything boring. Before the start of this new term, many of you will have read up on elementary materials about studying law. I don't know what pre-reading list you have been given. You may have read a book called Learning the Law, written by Professor Glanville Williams, now edited, I think, by Professor A.T.H. Smith. You might have read a book called What About Law? Studying Law at University, by Barnard O'Sullivan and Graham Virgo. And you may have read a book called Letters to a Law Student by Nicholas McBride. If you have not, make a note and try to look for them. As a further warm-up to your days at law school, I suggest that you should all watch an American movie called Paper Chase about first-year studies at Harvard Law School. Not for the story itself, because it is quite cliché, but for a dramatization of the Socratic method of teaching practiced by Professor Kingsfield in the movie. To cut a long story short, the Socratic method means that your lecturer or professor would pick you out of the whole class in the middle of the lesson. Hey, you, the guy in orange. And ask you tricky questions for the purpose of testing whether you have been paying attention or prepared for your class. I do not know whether Hong Kong U practices the Socratic method now, but I would suggest that Hong Kong U tells its students that it does. The university does not necessarily have to do it, but the mere risk of public humiliation can perhaps ensure that everyone stays awake and read their duplicated materials beforehand. You still have DMs, do you? Good. Generations of my pupils and summer students have often been forced by me to read the text of a speech by an eminent British judge and jurist, Sir Robert McGarry, which he gave to Hong Kong U in 1981, entitled Law as Taught and Law as Practiced. Professor Ho told me that it's not part of your duplicated materials, and I suggest that it be made part of the duplicated materials, because to me what was said more than 30 years ago still holds true today. The reference is round bracket 1981, closed round bracket 11, Hong Kong Law Journal, page 152. It provides a good deal of insight for law students, such as that even though you will be regarded as a good law student, or even get a first, if you score 80 points in your exam, at work, if you are only 80% right in your work, people will only remember the other 20% when you were wrong. A meeting of Hong Kong U graduates is going to be held tomorrow to discuss the controversy surrounding the appointment of the Vice President for Academic Staffing and Resources of this university. Because I have done 1 year of PCLL from 1987 to 1988, I am entitled to go or send a proxy. But let me declare, I am not going to do either. So this perhaps gives me complete freedom to say what I want to say without being branded one way or the other. There are 2 points that I feel must be brought out. First, I assume you've all followed the event. The original decision of the Council was to defer the appointment of the particular post of Vice President until the new Deputy Vice President, Deputy Vice Chancellor, Shao Fu, has been consulted. Recently, the decision has been modified on the ground that the candidate for the Deputy Vice Chancellor would not be known for quite some time, and so the appointment of the Vice President would not have to wait for him. This, however, does not mean that the unsatisfactory nature of the original decision is now water under the bridge, where, as in this case, a respected and respectable selection committee has scrutinized the credentials of relevant candidates or candidate, and there is at the moment no suggestion that they had overlooked anything, and made a recommendation. One would need very good reasons before one would decline to act on it. Depending on the precise rules and convention adopted by any particular institution, if the final appointing body has any good substantive reasons for not accepting the recommendation, it can either send the matter back to the selection committee for reconsideration or decline to accept the recommendation and back that up by good substantive reasons on the merits. Now, I'm not talking not about the nitty-gritties of any rules or regulations. I'm talking common sense. If, as the Council originally seemed to think, the matter is regarded as so important to have to wait for the next provost or Deputy Vice Chancellor, who was yet to be identified, for him to be consulted, one can legitimately ask, and I'm just asking, why the selection committee had been asked to recommend in the first place, and why the Council had to deliberate upon it with such care, only at the end of the day to say, oh, let's wait. Without putting too fine a point on it, the original decision to wait was contrary to what many would regard to be common sense and cries out for an explanation. Many had said that if it had not been for this particular candidate, things would not have blown up. Many lay persons would say, I do not know the candidate in question. I do not know whether he's a good chap. It is really a matter of politicking by politicians. Well, you will note that I have formulated the discussion just now without naming any names. The question is really candidate neutral. It could even be the subject of an examination in a subject called common sense, with the word X in place of any particular name. The point is equally valid. The matter is made all the more perplexing and infuriating by the fact that prior to and after the Council's decision, which I stress, says nothing about merits or demerits of the candidate, there had been unprecedented attacks and snipes against the candidate himself and the law faculty, whether in newspapers of a particular political inclination or in street banners, as we have now found out. If those snipes are truly good reasons that can withstand public, academic, and moral scrutiny, let them come out into the open and let the Council examine them and state them. But the snipers had chosen to snipe. It makes one wonder what they are trying to achieve and why they are willing to wound but afraid to strike. My second point is, we have all seen the scenes where student leaders force themselves into the meeting of the council, discounting the fact that some of those captured on TV and present at the scene that day might not be students, as Professor Yun Guoyong fairly pointed out. The undeniable fact remains that student leaders disrupted the meeting in a manner which is, put diplomatically, less than courteous. Some would say rude. We are not just talking about the impulsive act of entering, but what was shouted and done afterwards. What is disappointing is that, first of all, student leaders seem to want to stand firm on the correctness and justifiability of what they had done, seeking to glorify their acts by saying that they did it because of a violent system, 制度暴力. This, I regret to say, is a dangerous argument. As I have said elsewhere, two wrongs do not make a right. The fact that you perceive you have been wrong doesn't mean that you have to resort to something wrong yourself. And no one had ever come out to explain how, even if the system was violent that day, the break-in or the forcing in could help the students' cause. What is more disappointing is that in our polarized society, whenever there is any hint of adverse comment on the conduct of the students, adult forces and netizens that are sympathetic to the students would immediately counterattack by saying, "Oh, they were forced to do it. Why don't you criticize the other side?" Commentators who had been strongly critical of the council's decision are nonetheless condemned by student supporters simply because they had not wholeheartedly, unreservedly glorified or backed up what the students had done. And they had instead suggested that the students' conduct could backfire and harm their own cause. But in the eyes of many, that is not enough. They must wholeheartedly, unreservedly say the students are right. Some people just can't do that, even though their hearts are in the right place. This is almost a repeat of what happened in the later stages of the occupation. It may be that political leaders plan or say what they do and say out of all kinds of political calculations for fear of upsetting their allies or losing their democratic halo. But to the students, I repeat what I had said earlier this year. There indeed is a line to be drawn between nobility of ends and acceptability of means. Turning away from Hong Kong U to the judiciary, much has been said about judicial independence lately. I have spoken recently about it in an interview. I will not repeat it. You may all feel a good deal of apprehension as new law students as to whether you are about to enter a profession or a system which is being eroded or doomed. When you have meals with friends or relatives, they may ask you for your views about this recent incident or that recent incident. So it is a good chance for me to give you maybe a standard answer to one or two of these queries. What had particularly concerned me recently, and I've spoken about it in the interview, I'm sorry to say it again, is certain misguided and ill-informed discussions concerning the so-called breast attack case. There are people who had failed to or refused to understand the matter properly. The matter is currently under appeal, as I understand, so I shall refrain from commenting on the merits of the case. Broadly speaking, what happened was during an anti-mainland parallel importers protest in the New Territories, an incident took place between a female protester and a policeman. The factual findings made by the magistrate, as I understand it, is that after hearing the evidence from both sides, he found that the breast of the protester came into contact with the policeman in circumstances which he found to amount to an assault as a matter of law. He also found that the protester tried to falsely accuse the policeman for indecently assaulting her. Now, one can legitimately debate whether, on these findings, the extent of contact or the circumstances under which the contact took place amounted to an assault as a matter of law. One may also try, if one wants to challenge the findings of fact and say the facts were not as found by the magistrate or the deputy magistrate. All these will no doubt come out into the open when the matter goes on appeal. The beauty of our system is that whether the appeal is allowed or dismissed, there will be an open hearing, a reasoned judgment explaining in detail the factual and legal basis for the ruling. But a good deal of unwarranted public attention had been devoted to the fact that the case involved a certain female part. Demonstrations and protests had been held on the basis that it was an insult to women or an absurd ruling that women carry offensive weapons with them. People phone into radio stations, people write blogs, people write things on chat rooms, forums. This is a typical example where one misguided viewpoint, perhaps overly enthusiastic, could mushroom out of proportion. The accused in that case was not charged with carrying an offensive weapon. So any ridicule about women carrying an offensive weapon with them completely missed the point. You can commit an assault in law with almost anything. Your arms, your leg, your head, anywhere. And it's not essential that the assault be committed with the aid of any weapon. Given the correct facts, any part of your body can be used as a means to commit an assault. I repeat, you can debate and appeal any findings of fact or law that you regard to be wrong, but the reason why this case has been blown out of proportion is merely referable to the fact that it involves a certain sensational body part. To elevate the possibility, the mere possibility, and I express no view on the merits, of a decision wrongly decided on the facts or on the law, to the level of, as some would say, the death of the rule of law, or the corrosion of the judiciary, is, frankly speaking, not on. Now, there are bound to be people who will be unhappy with or unconvinced by what I have just said. I read the comments of my interview online, and there are people who refused to succumb. They will continue to maintain that the Hong Kong judiciary is doomed, filled with unqualified judges, infiltrated by police sympathizers. If you explain the above, what I said to them, they will look at you with disbelief and take from his drawer, sleeves, other, quote, examples where people are, in their view, wrongly convicted or, in their view, sentenced too harshly. If you give an answer to one, they will not budge. They would say, how about this case? How about that case? How about this case? How about that case? 七警又點啊？呢個又點啊？呢個又點啊？嗰個又點啊？ So they have a preconceived conclusion, and they refuse to budge. I will not try to persuade these people. Those who have already formed preconceived concepts can never be persuaded. But if any of your friends or relatives belong to this category, I hope not, I suggest to you the best way to deal with these people is not to get bogged down with them, but to invite them to have an open debate, perhaps organized by Hong Kong U, with representatives of blue ribbon organizations who had staged protests complaining about judges being too lenient, who have let off too many, who sentenced them too lightly, and complain that the judiciary is infiltrated with yellow ribbons. I would suggest that if ever such a debate were to take place, the ideal candidate for the adjudicator is Mr. Justice Thomas Au of the High Court. Mr. Justice Au obtained his LLB from Hong Kong U with first-class honors. He is one of the first bar scholars in Hong Kong. He obtained his Bachelor of Civil Law degree from the University of Oxford. he granted an injunction against some occupiers in the occupation movement last year. His decision was upheld by the Court of Appeal when they refused leave to appeal. That has not prevented netizens from calling him a blue ribbon or somebody who has become an ally of an illegitimate and violent regime to oppress the people. Fast forward to May this year, the same judge, Mr. Justice Thomas Au, quashed the decision of the Chief Executive in Council in the Hong Kong Television judicial review case. This was hailed as a victory of the rule of law and demonstration that the independence of the judiciary is still intact. He was even part of the subject of protesters mocking the judiciary, saying that the judiciary is anti-government. But he is the same judge. Is he yellow or blue? Or a green man? Whatever he is well suited to be an adjudicator. And I await with keen interest the outcome. If people dare to put their arguments for and against to the test at all. Everywhere in Hong Kong, whether it's the Faculty of Law or other faculties, if you look around you, you are bound to come across a fair amount of students from the mainland. In my tenure as the chairman and vice chairman of the bar in the past many, many years, I had the opportunity of coming in contact with very talented law students from top universities from the mainland who come to Hong Kong for exchange. I was impressed, even surprised, by how hungry, liberal, enlightened, and open-minded many of them were. I extend a warm welcome to students from the mainland to join the Hong Kong U Law faculty. On the note of mainland, in the past few years, Sino-Hong Kong conflict has become a fashionable topic. There are the usual culprits or radicals from both sides. On the one hand, there are what we would call Wu Mao, 50 cents, Mo, or angry youths, Fan Ching, who would write, if not for us mainland people who come to Hong Kong to do our shopping, Hong Kong would have ended years ago. Well, to regard that coming to shop in Hong Kong, indeed any overseas city, where shoppers actually pay to get something back, fair deal, to be a kind of bounty or CSAT, epitomizes the worst sense of the phrase 財大氣粗 that we have not seen even at the height of American and Japanese export of their tourists in the 80s. It also epitomizes a certain type of warped and distorted mindset that money is everything. But on the other hand, there are local factions or radicals who indiscriminately and irrationally call anyone from the mainland locusts and hurl abuse at them because they carry suitcases. No doubt there are mainland tourists who behave in a less than satisfactory manner, and if so, they can be told off firmly. But there are at the same time scores of mainland tourists who behave in a completely civilized manner, trying to shop and have fun here, like visitors from other countries. Barbaric gestures, blindly targeting them and making life unpleasant for them, bring Hong Kong a bad name. And the acts are petty, small-minded, and provincial. Discounting these two extremes, in between, and in a place like the University of Hong Kong, especially in the law faculty, where students are supposed to be liberal, open-minded, enlightened, there is a good deal of scope for discourse between local students and mainland students. But very often, meaningful discourse between mainland and Hong Kong is hindered by what I see to be a failure to agree on the basic parameters of discussion. Let me explain. For example, if you try to discuss Hong Kong views of discontent about the mainland, or vice versa, discuss certain views of mainland discontent about Hong Kong, one must identify the basic facts before one can proceed to discuss whether the discontent is justified on these facts. But the problem is that a Hong Kong person and a mainland person may understand the underlying facts or values in different ways. Therefore, when a Hong Kong person or a Hong Kong resident tries to explain to a mainland person or visitor that this, that, and the other are the reason why some people in Hong Kong are unhappy about the mainland, whether the government or the people, the mainland visitor would sometimes disagree strongly and say, well, that is not what we understand to be the facts. Or, really, is that what happened? That can't be so because the newspapers up here all say the opposite. Of course, the converse may happen. When a mainland visitor tries to explain to a Hong Kong person the reason why there are mainland discontent about Hong Kong, the Hong Kong person can equally say, well, that's not what's happening in Hong Kong. Where did you get that from? A diplomatic way or a nice way of handling such differences is to say that each should respect the views of the other. But that is an empty phrase. How on earth do you respect without getting to the bottom of it? Allow me to be blunt and be 大香港 for 1 second. Hong Kong enjoys an unrivaled and unparalleled advantage in having a free and unrestricted flow of information. If you search the internet in Hong Kong, you will not find a message that says the site you want to search does not comply with the relevant rules and regulations and have been blocked according to law 依法被禁 or 依法 whatever. On the newsstand, you can find publications covering a spectrum of political views, more so on the internet. Some people complain about biased reporting by some news media, but by and large, news media do not provide a one-sided view of matters. You can choose. With an unrestricted and free flow of information, of facts and values, with a true marketplace of ideas in Hong Kong and in Hong Kong U, on the whole, I stress, on the whole, I dare say that there is a higher chance of a more informed view being formed in Hong Kong. Of course, even for local Hong Kong people, there are those who are unwilling to open up their hearts and to only read what they want to read. One-sided news, one-sided views. For those, you can't really help them much. But at least for those who want to and who are hungry enough to want to know, they can have ready and easy access. And that is why I say, on the whole, there is a higher chance of a balanced and well-informed view being formed in Hong Kong. At the same time, for example, of reading Stand News, 立場新聞, 852 852郵報, Passion Times, 熱血時報, you can also access Speak Out Hong Kong and HKG. You can Google to find these. You won't find a block. I would encourage our friends from the mainland to make good use of this advantage. I know that many of you are already very good in overcoming the Great Wall of China or using VPN. But there is no substitute for being here yourself, seeing and breathing what we see and breathe. Having uninhibited, I stress, uninhibited access to information and views. Just walk into the bookstores. What you may have to strenuously and secretively obtain at home are freely available. Once your eyes and heart are open, they cannot be closed again. Many people ask me why every time I speak publicly, I seem to have so much discontent to vent. Well, I watched the Disney movie Inside Out this summer. Afterward, I did an online test about which of the inside-out emotions I represent. It turned out that I was anger. I did it again last night, and I was still anger. So the result should be more or less reliable. Now, it does not mean that I go about venting my anger by throwing tantrums or beating people up. According to the website, the description of anger actually is, you have a fiery spirit and little patience for nonsense. You've been known to get fiercely passionate about both enforcing fairness and making sure people don't ruin perfectly good pizza. Because I think the first question is, what do you react to putting broccoli on pizza? You can try to Google it. Well, we should all be grateful that here in Hong Kong, indeed in many places in the world, people still remember how to be angry. There are places in the world, such as that depicted in the dystopian novel, I hope you all know what a dystopian novel is, called 盛世, 盛世, forgive my 普通话, 盛世, written by the renowned local writer Chen Guizhong, who spent a long time living on the mainland. It's a book banned on the mainland, where many people in the book had forgotten how to be angry. They chose to forget about recent history. They were fed a drug by the government called MDMA, which made them feel perpetually 幸福 and live under a false sense of contentment. This is perhaps one of the rare contexts where one can say it is good to be able to be angry. Before this lecture, I asked Professor Ho for campus security, because one way or the other I may be mobbed. I intended that to be a joke, but she told me she did make arrangements. I hope I do not need to resort to their assistance, but that depends on your reaction. Thank you for listening.